Hey everybody, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to talk about whether or not your estate plan can be a set it and forget it type of thing. Before we get there, however, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. So when we're talking about a set it and forget it plan, most folks think that when they sit down and speak with an attorney about setting up a will, just a will, or getting their incapacity planning documents such as a power of attorney or health documents in place, that they do it once and they never have to think about it again. I can't really count how many times I've had folks come to me and say, you know, we did a plan, but it was like 30 years ago and our kids were little then, or we only had 2 of our 3 kids then, and various scenarios where a adjustment was needed, but many, many, many years later. Those changes may actually be required sooner in life because your life isn't stagnant, is it? Things shift. They change. Our children get older. There are so many circumstances that impact what that plan may look like. And so it's super important that when you set your plan up, you're thinking about that moment in the next few years with, of course, flexibility toward the future. But that you also have a conversation with your counsel once a year, or just make sure they're checking in and you're thinking about your plan, that nothing major has changed in your life. Of course, your attorney hopefully will reach out if there's been any major changes in the law that impact you. But every few years, I would say, and that's how our firm practices, every 3 years or so, we'd like to have a more concrete conversation to actually go through the choices that were made in the past to see that they still fit the future needs, circumstances, and wishes of our clients. We just don't know. It could be a parent we had designated who's now aging, and they should no longer have a fiduciary role. It could be our children who are getting older and may take a role that they didn't previously have because they were children. Many circumstances, and we have to go through those, and we have to consider them. We may acquire additional assets that mandates that we do additional planning of some kind, advanced planning beyond sort of the basic that we started out with. So keep in mind that all stages of life require some kind of plan, whether you're 18 and just need to have some incapacity protection, a young family, a person close to retirement, or in the stage of potential illness and wanting to plan for long-term care and asset protection. All of these stages require a plan, and hence your plan needs to change with those stages. So reach out to your attorney if you have one. If you haven't yet and you're over 18, get on the horn, do it, have a conversation. You have plenty of opportunities out there to have a free consult with attorneys. I know many of them just as colleagues around the nation, and figure out what it is you need. Get one started and then adjust as time goes on. Hope this information is helpful. And as a reminder, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for watching. And if you found this information useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.